Welcome to everybody in this post-refreshment, because post-refreshment session is always difficult to handle, because in the inauguration, the stalwarts, the keynote speeches are there, so always persons would be there to attend. But after this kind of session, it is difficult to see the faces again in the conference room. You back to the second session. Thank you very much. Thank you. And I'm privileged because since morning we are talking about the subject, about the international arbitration. But I'm fortunate that the seniors and the professionals sitting over here has not touched or talked about the investment arbitration. So that's why a little bit was in a nervous mood. That subject is new. Even also talked to me during the session that subject is new. I'm confident that it's a new subject. I will be able to talk to the participants on the subject, on the basics, rather than going into the intricacies. Though subject is not new, but we are not exposed to the investment arbitration, and that's why subject is new. But let's see how best we can use the time given to me, 20 minutes, and we'll be able to touch upon the certain concepts by which we can start understanding, learning, and other practicing in this area of the international arbitration, that is not the commercial but the investment arbitration. Yeah, so investment disputes in India, there's an in-house counsel. So I am told to design the talk with a specific focus to the in-house counsel. We know about the international arbitration, and we have talked about the commercial arbitration, but the topic of the day is the investment arbitration. It's a branch of the international arbitration, which many of us, though are fully aware, but as I've told you, don't have much exposure, don't have much, the understanding, and that's why we have not been able to deal with the subject in a regular conferences like this. So I would like to first of all thanks Walters and Clovis for choosing up this topic and giving opportunity for me to deal with the subject. For which, the important concept, most important treaty is the bilateral investment treaty. So we must understand what is BIT and its law and procedure. So we know international arbitration, which arises out of the contractual dispute between the two parties. But the investment treaty arbitration, that is the investment arbitration, arises against the treatment of state B. If investor X is from state A, and there is a bilateral investment treaty between state A and state B, and when Mr. X, the investor of state A, investing to state B, and when there is some action to be arisen, some claim has to be made against the state B for the various reasons which we'll discuss later on, then foreign investor can take the shelter of this treaty, BIT, bilateral investment treaty, against the state. So it is not against the party. Basically, this is the fundamental difference which you must understand. In an investment treaty, arbitration is always a state is respondent, since deemed breach is always committed by the state, not by the party. So the bilateral investment treaties are, as you are fully aware, but are treaties signed between two or more states, which is basically to assure the protection, to give a favored treatment to the investor of the other state. And these treaties are signed to encourage foreign investment between the two signatories, those who have signed the bilateral investment treaties. And these treaties basically to protect the right and investment of the foreign investor of the other state A and state B again. So if there is a bilateral investment treaty between A and B, and vice versa, if X is a resident of state A investing in state B, then yes, bilateral investment treaty always is there to protect the right the investor of state A who is investing in state B. So let's have a background of the bilateral investment treaty. As I have told you, my dear friends, this is not a new subject, new topic, because this concept is internationally known to everybody since 1959, but we don't have much exposure. In India also this subject and bilateral investment treaty have been incorporated, have been model text of the BIT, is first approved by Government of India in 1993. Since 1993, we have 80 bilateral investment treaty between India and the other states. That is the fact of the case. First treaty was between UK, and now we have 83 states. But the present scenario is something different, and that's why I think topic is chosen. In 2015, this treaties, those who are in existence in operation today, are based on the 1993 model text. But situations arises which you all know in recent past against the Indian government. Various claims have been lodged by the multinational companies against the Indian government, and that's why I think in 2015 revised new model of bilateral investment treaty have been now announced by the Government of India. Why this revision has to take place? Because revision in India has to take place because Indian government have been dragged into the international arbitration by many of the multinationals. Just to name a few, which you know, are the Vodafone, Systema, the vast dispute, and well known is the Vice versus Government of India, Australian investor. My dear friends, I would like to inform you that today, Indian government already issued notice to 57 countries out of 83 countries to terminate this BIS and to enter into the new bilateral agreements based on the model of BIT 2015, which is at present based on BIT 1993. So this is the entire scenario of the bilateral investment. Investment treaty arbitration both way possible because I am an in-house counsel of the company. In case there is an outbound investment, then as an in-house counsel we do check that whether there is a bilateral investment treaty prevailing between the India and the state where my company is investing. And if yes, then as a counsel we have to study this bilateral investment treaty. And like MNCs have filed suits against India, tomorrow if there will be some discrimination, some treatment which is not favored to the company as per the bilateral investment treaty, then you as an in-house counsel of company, Indian company, can also guide to take shelter and invoke the provisions of bilateral investment treaty against the state where your company has not got the equal treatment. So the state of the investor had a bilateral investment treaty with state where investment is made by investor. Certain action of the state, when I can invoke, certain action of the state where investment was made has affected the investment adversely because of the number of reasons. Those actions of the state violate the BIT commitment. If the investment of the investor fulfills the requirement of condition of bilateral treaty, period, precondition, type of the investment. The most important thing is the in-house counsel, we must know that when I am talking about the outbound investment, then I also have to ensure that the Indian company have to fulfill the various basic requirement of the period of investment, of the registration with the local authorities, of various tax compliances, and the so on and so forth. That is what is the role and responsibility of in-house counsel can be. And when it comes to the inbound investment, then also how inbound investment, I as a as an in-house counsel can take this benefit of treaty. I am a 100% wholly owned Indian company. So when a foreign company has the 100% wholly owned subsidiary in India, and I am the in-house counsel of that 100% wholly owned the Indian company, yes, then that company which is outside the India, which has invested in India, then yes, I also have to take care and protect the interest of my holding company. And if my holding company is not fully aware about the bilateral investment treaty between the state A and the India, then I as an in-house counsel also have to study this bilateral investment treaty between the holding company and the India, and has to see that if any unequal treatment is not given or received to this holding company by the Indian government, then yes, we can also take shelter and guide our company to take the benefit of this bilateral investment treaty which is in place today. So, why and how I can invoke, how I can take the benefit. Bilateral investment treaty basically gives a guarantee to the foreign investor by way of the fair and equitable treatment, FET. If X of state A has invested in state B, then state B tomorrow cannot come out with a condition that a foreign company cannot apply for the tender of the nature and activity in which X of company A is invested in B, state B. So this kind of discrimination cannot be there. Fair and equitable treatment has to be given to the foreign investor. Full protection and security. Sri Lanka. Sri Lanka, those who are senior sitting over here are fully aware that in Sri Lanka, because of riots and the terrorist activity, the foreign investor who had invested their money into Sri Lanka have requested and demanded Sri Lankan government to incorporate this clause into the bilateral investment treaty between their countries and Sri Lanka, so that in any case of any damage because of the riots or because of the terrorist activity, the Sri Lankan government would take care and would compensate to the foreign investor. No expropriation. So tomorrow, because of the bilateral investment treaty exit, tomorrow the government B, state B, cannot come out with an announcement and notification that now X of state A, with whom we have a bilateral investment treaty, cannot, that company and nature will be nationalized, like telecom, like insurance. Insurance players are here. Tomorrow, Indian government cannot come out with the notification that there will be no foreign investor in the insurance company. If there, then we also certain conditions will see. But these are the basically guarantees given by the bilateral investment treaty to the foreign investor. And the next is most favored nation treatment. That is denial of privilege treatment. We'll see that also. Effective dispute resolution mechanism. Yeah, as far as India is concerned, many of foreign investors and the business community is worried about the effective dispute resolution mechanism because of time that many of the earlier speakers have also mentioned. So in BIT, that is also a support for the effective dispute resolution mechanism as far as time is concerned. Yeah, so we were talking about the FET, fair and equitable treatment. Some 2 or 3 important concepts will also dealt in little detail. What is fair and equal treatment? If there is a denial of justice, if there is fundamental breach of the due process, if due process is not being carried out by the state B, where X of state A and invested his money, targeted discrimination on manifestly unjusted ground, gender, race, and religious, some restrictions have been imposed. Abusive treatments, the harassment, etc., have been made by the state B for the Mr. X of state A, where there is a BIT in existence. So if this kind of things are in existence and things happen, then yes, it can be argued that there is no fair and equal treatment is given to the foreign investor by the state B. Another important concept also should be understood is the most favored nation clause. Most favored nation clause allows linking the different investment treaties. There is a treaty between A and B, but when treaty between A and B, and when X has invested in B and has affected, his investment has got affected, then again the duty of the and responsibility and role where in-house counsel can play is to see how many countries we have a bilateral investment treaty, like India, for example, and we have to see that in any other treaty, if there is a clause which is favorable to state A, then we can take a plea of this, and then we can say that most favored nation clause is affected, and that is basically the case of that Australian company which we have talked about. Because there was a clause in the Iraq or somewhere where they have taken the plea that this most favored nation clause is not there in India Australia BIT, but the clause is there in the effectiveness. Clause of effective application was not there in the India Australia, which was there in India Iran or somewhere. So that was the case of the Australian company. So this clause allows linking difference investment treaty, and it also allows investor to choose the provision of those BITs that give them the maximum benefit, as we have just discussed. It was, White Industries versus Government of India, that Australian case, which is known to many of us. Permissible exploration. These are the permissible. We said if there is a exploration, then it is a violation of BIT, but these are the permissible exploration where BIT shelter cannot be taken. Public interest, if it is against the public interest, should not be discriminating or arbitrary. Due process of law, if has been taken, and after payment of adequate compensation. If adequate compensation have been paid to the foreign investor, then we can say it is a permissible exploration. Which are the forums to be approached for the investment treaty arbitration? ICSID. Though India is not a member of the ICSID, to my personal view, still we can approach the ICSID whenever there is a breach of any of the provisions of bilateral investment treaty. This is my personal view. An international arbitration institute which is designated investment treaty. Investment treaty has specifically mentioned about the arbitral institute, then yes, that would be the arbitral institute for the investment treaty arbitration. Law applicable will be the public international law. For the interpretation and for every other matter, the law of public international law will be prevailing. Many investment treaty arbitration happens under the UNCITRAL rules. That is common. Enforcement, because that is very important. Enforcement of the treaty, arbitration award. Award can be enforced under New York Convention, as we have discussed earlier also, that there is no point of further discussion. It is enforceable, and there are 136 countries to New York Convention, which you all are fully aware, meaning thereby this award is enforceable. Investment treaty arbitrations are expensive. Because of the reason known to you, there are no much arbitrators, no much lawyers, no much counsel available today to represent. If I have either in-house counsel decided to represent this case before any of the international arbitral, when there is a treatment given to me in the host state, that is investment state, by the host state B to the investor X of investor state B. So that kind of, why it's expensive? Because the counsels are not available, the arbitrators are available, and the subject is new. And so I am considering this as a great opportunity for the arbitral professional. This is again a great opportunity to venture into this new area. Though not new, but as I again told you, we are not exposed much to this area. Most of the states settle matters once enforcement actions are filed in the national courts. So this is again a scenario which is going on in the country right now. For the planning outbound and inbound investment, as an in-house counsel, we should study the BIT between India and your proposed investment destination. Because all BITs, as like all treaties, all BITs are not same. There are most preferred nation clause available somewhere, not available somewhere. So all BITs with India are not same. So you should not take a risk and chance that I have studied the BIT between India and Australia, and now my company is investing and making outbound investment in Germany, so I can take 100% recourse from that particular BIT cannot be the case. So as an in-house counsel, we should study when my Indian company is making outbound investment, follow the conditions of investment strictly as we have discussed earlier also. There are treaty-specific, country-specific conditions required for a special registration, for the regular tax compliance, for the special reporting to the various designated in-house counsel wanted to make the outbound investment. So I also have to see all these things are being applied not only on registration, but only when the company is in operation on a yearly, on a quarterly, on a time-bound manner. Then only if case there is a dispute arises, I can take shelter, I can take plea against this bilateral investment treaty. And if I have not complied with the various this statutory requirement, which is there as per bilateral investment treaty between India and Germany, and tomorrow I am going with this claim against the Germany, then if I have not complied with this all statutory reporting, tax, other compliances, then it will be a very difficult case for me to again argue. Follow the changes and updates. Yes, it is not that once we have entered into I have made an investment and I can just take back seat and get relaxed. When dispute arises or something arises, I can go and claim. No, I have to ensure that the company, Germany, my company who invested in Germany, also have to follow all changes and update of that state, so that investment of your company as far as outbound or inbound investment will be safe and secure. Thank you very much. And India will be still remaining as a preferred destination for inbound investment, though India